Welcome to all. As a part of the course on insolvency and bankruptcy laws in India, today we are going to discuss nature, scope and contents of resolution plan. So in the previous class also we have discussed nature, scope and contents of the resolution plan. Continuing that, today also we are going to discuss nature, contents of the resolution plan. Let us recap what we have discussed yesterday. In yesterday's class we have discussed nature and scope of the resolution plan. Then we have discussed the contents of resolution plan under regulation 37. We have discussed each and every clause in detail. Like resolution plan can have transfer of all or part of the resolution assets and sale of all or part of the assets, whether subject to any security interest or not, restructuring of the corporate debtor, obtaining approval from the other authorities. So what can be there in the resolution plan? The contents resolution plan yesterday we have discussed in detail. So today we are going to discuss mandatory contents of the resolution plan. So whenever you are preparing any resolution plan, so these are all the mandatory contents to be there in the resolution plan. So today we are going to discuss the mandatory contents of the resolution plan. So today our agenda is to discuss section 30 of IBC and regulation 38. Mainly we will concentrate on section 30 and regulation 38. Incidental to that, we may look at other sections also, but majorly we are going to concentrate section 30 and regulation 38 of CIRP. Now let us start. If you observe section 30 subsection 2 clause A, which provides that for the payment of insolvency resolution process costs in a manner specified by the board in priority to the payment of other debts of the corporate debtor. So whenever you are drafting the resolution plan, whenever you are framing the resolution plan, first of all, the resolution plan shall contain the details as to how you are going to make the payment towards the resolution process cost. Because first you are supposed to pay the insolvency resolution process cost first. Then only you can pay to other people. Okay, so first you have to pay to the insolvency resolution process cost. So how you are going to make the payment? So this has to be there in the resolution plan. Okay. Then, what is the meaning of resolution process cost? So, insolvency resolution process cost means it is defined under section 5 subsection 13, which means the amount of any interim finance and the cost incurred in raising such finance. Suppose while continuing the resolution process, maybe the resolution professional may require some interim finance. So, if you are raising any interim finance or any cost that is incurred in raising the such finance, okay, that is considered to be insolvency resolution process cost. Then the fee payable to any person acting as a resolution professional. So obviously resolution professional, fee is payable to him as per the regulations. So any fee that is payable to resolution professional will form part of the insolvency resolution process cost. Then any cost incurred by the resolution professional in running the business of the corporate debtor as a going concern. So one of the requirement or one of the obligation of the resolution professional is that he is expected to do the business as a going concern when he is taking over the management of the company. So going concern of the business is one of the essential character of the IBC. So that's why, okay, so if any cost is incurred by the resolution professional in running the business as a going concern, so such expenses will form part of the insolvency resolution process cost. Then any cost incurred at the expense of the government to facilitate insolvency resolution process. So if the government has incurred any expenses to facilitate the resolution process, then such expenses must be a part of insolvency resolution process cost. Then any other cost as may be specified by the board. So board is going to specify specifically. So then all these costs will be part of insolvency resolution process cost. So please remember, whenever you are preparing the resolution plan, such resolution plan mandatorily they should give how they are going to make the payment. Okay, first you should make the payment towards the insolvency resolution process cost. So this is one of the mandatory content of resolution plan. Then how you are going to make the payment to operational creditors. So here when you are making payment to operational creditors, so we are having minimum value to be payable that is discussed under section 30 subsection 2 clause B, which clearly provides that which provides for the payment of debts of operational creditors in such manner as may be specified by the board, which shall not be less than. So how much amount you are supposed to pay to the operational creditor. So when you are giving the resolution plan should give these amounts. Okay, the amount to be paid in such to such creditor in the event of liquidation. Suppose if the liquidation is happening immediately, how much amount you are supposed to pay to the creditor, operational creditor. So such amount must be paid. Then the amount that would have been paid to such creditor, if the amount to be distributed among under the resolution plan had been distributed in accordance with the order of priority. So under section 53 of the Act, we are having waterfall mechanism. So if as a part of the resolution plan, if you are distributing, how you are going to distribute, okay, out of the total available assets. In the subsequent lessons, you are going to discuss when you are discussing the concept of liquidation by another faculty. So we are going to discuss how you are going to make the payment. So that is called as waterfall mechanism. What is the minimum amount that you are expected from the waterfall mechanism? So that amount you are expected to pay to the operational creditor. So this is the minimum value to be payable to the operational creditors. Then whichever is higher, please remember. So we are having the amount to be paid to such creditor in the event of liquidation and under the waterfall mechanism. So whichever is higher, that amount must be paid to the operational creditor. So and provides for the payment of debts of financial creditor who do not vote in favor of the resolution plan. So please remember, if any financial creditor is not voting in favor of the resolution plan, because the COC committee of the creditors, they are going to sit, they are going to approve the resolution plan. So in the committee of the creditors, financial creditors will be there. Possibility is that some of the financial creditors, they may not accept the resolution plan. So whoever is not accepting, whoever is not consenting, whoever is not voting in favor of the resolution plan, then even he is also entitled to receive the payment, okay, in priority to other people. Okay, then payment to operational creditors, payment in priority. So this section further provides that you are supposed to make the payment in priority, so before making payment to other people. So if you observe regulation 38 of the CIRP regulations, okay, so the amount payable under the resolution plan to the operational creditor shall be paid in priority over the financial creditor. So when you are making payment to the financial creditor, the amount payable must be in priority over the financial creditors. Okay. So in the case of JP Kensington case law, the Supreme Court held that payment in priority means payment in cash, not in kind. So when the law is saying that payment in priority, so don't be under the impression that you can pay in kind. You are expected to pay in cash only. So in another case law, Pallavi Joshi Bakru versus Universal Buildwell Private Limited. So in this case law, NCLT New Delhi bench held that they rejected the resolution plan which provided the payment in kind. So as already we have discussed, regulation 38 clearly provides that the payment must be in cash only. You cannot pay in kind. So if any plan is there which is proposing payment to the operational creditors in kind, such resolution plan cannot be approved. Okay, so that's why in the case of Pallavi Joshi Bakru versus Universal Buildwell Private Limited, they have rejected the resolution plan. Now when you are making payment to the operational creditor, as already we have discussed in the previous slides, okay, so the payment must be in priority. Okay, there is one condition, and you should pay minimum value. Okay, so minimum value is one condition and the payment must be in priority. Third condition is that, okay, so if you look at the screen, third condition is that fair and equitable manner. So whenever you are making the payment must be fair and equitable manner. Okay, so it is which is provided under section 30 subsection 2 clause B. So if you observe this section, explanation is there. Okay, so in the explanation, it is not there in the main section. In the explanation one, it is provided that which is explained that for the removal of debts, it is hereby clarified that a distribution in accordance with provisions of this clause shall be fair and equitable. Okay, so whenever you are distributing in accordance with section 30, it should be fair and equitable. So in the case of SR Steel case law, so the Supreme Court held that the explanation did not mandate equal treatment. So when you use the word or when you look at the explanation, if you observe, please look at the explanation one. Okay, for the removal of debts, it is hereby clarified that that distribution, a distribution in accordance with the provision of this clause shall be fair and equitable manner. So they are not saying that equal. Okay, it is equitable manner. So there is a difference is there between equal and equitable. So we are not expecting the equal treatment because all the creditors are different classifications. Okay, they are in different classes. Okay, so that's why you cannot treat the unequals equally. Okay, so what we are expecting is equals must be treated equally, unequals must be treated unequally. Okay, so a proportionate payment to all the classes of creditors will be sufficient. Okay, so suppose if I am making payment to the extent of 30% to one class, then to another class also I am supposed to pay 30% only. Okay, so all the creditors may not be considered, but in each and every class I should treat them equally. Okay, then dissenting financial creditors, as already we have discussed. Okay, so dissenting, in case of dissenting financial creditors also, you are expected to pay, or you are expected to provide minimum and payment in priority. Okay, minimum payment and payment in priority. So if you observe section 30 subsection 2 clause B, which provides that for the payment of debts of financial creditor who do not vote in favor of the resolution plan. So if any financial creditor, if he do not vote in favor of the resolution plan, okay, then in such cases, okay, so you are expected to make the payment in priority. In the case of Rahul Jain versus Ravi Scenes Private Limited, the Supreme Court held that the dissenting financial creditors may be treated differently from the assenting financial creditors. Why? Because though they belongs to financial creditors category only, but one is dissenting financial creditor, another is assenting financial creditor. So the resolution plan can treat both of them separately. Okay, dissenting financial creditors and assenting financial creditors, they can treat them separately. Then let us look at the mandatory statement to be contained as a part of the resolution plan. So what are all the mandatory contents? So if you observe regulation 38 1A, which provides that a resolution plan shall include a statement as to how it has dealt with the interest of all the stakeholders. So how you are going to deal with the interest of all the stakeholders? Are you going to protect? How you are going to make the payment? Okay, so what is the guarantee that after the resolution plan is successful, okay, you are not going to close the company? So when you are talking about the interest of stakeholders, it includes employees also. Okay, so if you are closing the company after taking over, then employees are going to lose the employment. Okay, so here you are supposed to give the information as to how you are going to protect the interest of all the stakeholders. So maybe your financial creditors, your operational creditors, corporate debtor, employees, government. Okay, so everyone has to be considered while you are framing the resolution plan. So as per regulation 38 1B, a resolution plan shall include a statement giving details if the resolution applicant or any of its related parties has failed to implement or contributed to the failure of implementation of any other resolution plan approved by the adjudicating authority at any time in the past. So when there is prospective resolution applicant, when he is submitting the resolution plan, the resolution plan shall specifically state whether is there any former default, I can say. Okay, so previous default. So whether did they follow, I mean, is there any already existing CRP process, resolution plan is there, whether such plan was implemented properly or not, is there any failure in implementing such plan previously, are you the contributory, are you the related party? So you are supposed to give the declaration that we are not involved in failure of implementation of any resolution plan. Why? Because if there is a failure is there previously, obviously even in the near future also, even in this case also, there is a possibility of failure. Okay, so that's why the law is insisting you that there should not be any failure. Okay, then in the case of Panchtatva Promoters Private Limited versus GPT Steel Industries Limited, NCLAT held that a person who has failed to implement a resolution plan or has contributed to such failure, please remember they are impliedly treated as disqualified. Though when you are talking about the disqualification of resolution applicants, in the previous classes we have discussed about the ineligibility to act as a resolution applicant. In the previous classes we have discussed. Okay, so if any resolution applicant who has already filed resolution plan in some other case and who failed to implement such resolution plan previously, then in such cases, such resolution plan is not eligible to act as a resolution applicant in this case. Okay. Then resolution plan should provide for management of corporate debtor post approval of the resolution plan. So when you are taking over the company, when the resolution plan is proposed, subsequent to the resolution plan, once it is approved, how you are going to manage the corporate debtor. Okay, so how you are going to implement the resolution plan, because the resolution plan shall have the details as to how you are going to implement, how you are going to raise the finance. Every detail must be there in the resolution plan. Okay, so if you observe section 30 subsection 2 clause C, which is clearly providing that the resolution plan shall provide for the management of affairs of the corporator after approval of the resolution plan. So how you are going to manage the company, please give the details in the resolution plan. Okay, then you are supposed to give the details as per clause D, the implementation and supervision of resolution plan. How you are going to implement, maybe you can give the time framework. So within 3 years we are going to complete the resolution plan, because sometimes it takes some years. Okay, then who is going to supervise, who is going to be appointed at the C level, maybe CEO, CFO, CEO. Okay, so who is going to be appointed, who is going to supervise the resolution plan. So all the details must be given in the resolution plan. So in the case of SR Steel case, the Supreme Court held that the plan shall also provide for the term of the plan. Okay, so when you are implementing the plan, maybe the term may be 5 years, 6 years. Okay, and management and control of the business of the CD during such term. Who is going to manage, who is going to control? So are you appointing anyone exclusively who is an expert in that? Okay, and its implementation, and it also demonstrate that it is feasible and viable. So you should give a convincing answer, or else you should give convincing explanation that the resolution plan that you are proposing is feasible, how you are going to achieve, or it is viable. Okay, how you are going to recover the company from the debts. So this thing you are supposed to give in the resolution plan. Then in another case law, SM Milkos Limited versus Parvinder Kumar Bhatt. In this case law, NCLAT held that an agency or a committee in the nature of monitoring committee is a mandatory requirement. So when you are proposing the resolution plan, please, as already I told you, maybe you can propose CEO, managing director, or CFO, so and so person, whoever is having some expertise knowledge, you may propose. Okay, so that's why the resolution plan may propose an agency or some committee. So obviously you cannot run the company with 1 or 2 people, one committee may be required. So in the nature of monitoring, the committee is mandatory requirement to be provided. Okay, so the committee or the agency, whoever is going to manage the company, so specifying the details about this agency and committee is mandatory in case of resolution plan. Okay, so which is charged with the supervision and implementation of resolution plan. Then provision for continuation of the proceedings for avoidance of transaction. So you are going to discuss more about avoidance of transactions in the subsequent lessons. Okay, when you start the concept of liquidation, there you are going to discuss in detail avoidance of transactions. Okay, so in the resolution plan, you are expected to have how you are going to proceed or how you are going to deal with avoidance of transactions. Okay, so these things must be there in the resolution plan. So if you observe regulation 38 2D, which provides that the manner in which proceedings in respect of avoidance of transactions, if any, under chapter 3, are fraudulent or wrongful trading under chapter 6 of part 2 will be pursued after the approval of the resolution plan, and the manner in which the proceeds, if any, from such proceedings shall be distributed. So how you are going to deal with avoidance transaction? Okay, so we are having various categories. Even in the previous classes also we have discussed the concept of avoidance of transactions. Okay, so how you are going to deal with avoidance transaction, how you are going to realize such proceeds, after realizing the proceeds, how you are going to distribute among the creditors. So these things you should be very clear. So these things must be specified in the resolution plan. Okay, it's mandatorily. So in the case of Venus Recruiters Private Limited versus Union of India, the Delhi High Court held that the primary benefit, so you are going to mention about avoidance transaction. and you are also going to mention how you are going to recover the avoidance transaction. So when you are recovering this avoidance transaction, please remember the primary benefit of these proceedings from the avoidance transaction should go to the creditors only. First, it should go to the creditors because they are the victims. Okay. Then let us discuss other mandatory contents in the resolution plan. So if you observe regulation 38.3, these are all the various mandatory contents. Okay. So it addresses the cause of default. Okay. Then is it feasible and viable? Then it has provisions for its effective implementation, how you are going to implement the plan you should have. Then it has provisions for approval required and the timeline for the same. So possibility is there as a part of the resolution plan, or when you are doing this plan, if implementing this plan, you may have to take approval from various people, various authorities, maybe RBI, maybe TRI, maybe CCA, etc., etc. Okay. So what is the time limitation that you are proposing? Must be there in the resolution plan. Okay. The resolution applicant has a capability to implement the resolution plan. Do you have the capability to implement the resolution plan? Please consider. Okay. These things must be there. Then if you observe section 32E, okay, so which says that it does not contravene any provision, any of the provisions of the law for the time being enforcement. So you should give a declaration that the resolution plan that you are proposing, the prospective resolution applicant, whoever is proposing, the resolution plan must give a declaration that it is not going to contravene any of the provisions of the law. So maybe some other legislations may be attracted, like PMLA, okay, or maybe FEMA, maybe CCA, like there's so many other legislations are there. Okay, so you are supposed to give a declaration that you are not going to violate or you are not going to contravene provision of any other law for the time being in enforcement. Okay, then if you observe section 238 of the IBC, which says that IBC will override other legislations. Does it mean that you can contravene other provisions? No. Okay, so when IBC is not in contravention, then you cannot invoke section 238. Section 238 will protect you only, okay, if any other legislation is in contravention of IBC, or if there is any contradiction is there between the IBC and other legislations, then only you can use section 238. Otherwise, in the normal circumstances, you cannot use the section 238. Okay. So in the case of JP Kensington case law, the Supreme Court held that the resolution plan cannot seek more than what other law permits. Okay, so and cannot be used as a ruse to escape binding procedures and conditions under other applicable law. So because section 238 of the IBC is saying that IBC will have overriding effect over the other legislation, it does not mean that you are contravening the other provisions. Okay, so you cannot use the IBC proceedings to circumvent or to bypass the procedures under the other legislations. Okay, so that you have to give a declarations accordingly. Okay. Then provident fund use. Suppose if you are having any provident fund use are there. Okay, then how you are going to deal with the provident fund use in the resolution plans? So section 11 of EPF Act, which clearly provides that the monies owed to provident fund authority shall enjoy first charge over the assets of CD. So in case of liquidation, okay, so the money which is owed to the provident fund authority shall enjoy the first charge. So you are supposed to give priority to the provident fund. Okay, so even not only under section 11 of EPC, even if you observe section 36 of the IBC, which clearly provides that section 36 subsection 1 clause A subclass 3, okay, which clearly provides that the following shall not be included in the liquidation estate. Okay, so it shall not be used for the recovery in the liquidation. Okay, so what cannot be included? All the sums due to any workman or employee from the provident fund and pension fund and gratuity fund. So if money is maintained, if any fund is maintained by the employer, okay, which is related to workman dues, okay, related to provident fund, pension fund, gratuity, though the fund is there with the company, such fund cannot be used or cannot be considered as a asset. Okay, so you cannot use it. So in the case of Kushal Limited versus Regional Provident Fund, the Supreme Court held that the provident fund use, including any penalty, must be paid in full. So there is no other question. Okay, so provident fund you cannot touch or you cannot use, you cannot consider provident fund as an asset, though the company is having some funds in their account. Okay. Then let us discuss about obligation of resolution professionals. So if you observe section 30 subsection 2, the resolution professional must conduct the due diligence. This point already we have discussed in the previous classes also. The resolution professional must conduct the due diligence. Then regulation 33 provides that the resolution professional shall present to the committee of the creditor for its approval such resolution plans and which conform the conditions referred in subsection 2. Okay, so after conducting the due diligence, you are supposed to present the resolution plans before the committee of the creditors. Then regulation 39 subsection regulation 39(2) provides that the resolution professional shall submit to the committee all the resolutions plans which comply with the requirements of the code and regulations made thereunder. So as already we have discussed in the previous classes, it is the responsibility of the resolution professional to submit all the plans before the COC. Then COC will decide. Okay, the power to decide whether a resolution plan is valid or not, it is not vested with the resolution professional. Okay, it has to be decided by the COC. Then how you are going to do the voting? Okay, here we'll discuss about the voting briefly. Why? Because already in the previous classes we have discussed in detail about the voting rights. Okay, so if you observe section 30 subsection 4, the committee of the creditors may approve a resolution plan by voting of not less than 66%. Okay, then NCLT in the case of UCO Bank versus PMT Machines Limited, Mumbai bench held that where none of the plan voted upon the suppose take the example, they have placed various plans, the resolution professional placed various plans before the COC and none of the plan is approved with the 66% majority. Then in such cases, okay, the resolution plan that has received the highest vote below 66% must be placed once again. Then you have to put to vote revoting. Okay, you have to conduct the revoting once again. Then accordingly, if the same is voted with the 66%, then such plan will be considered to be approved. Okay, that is how you are supposed to do the voting. So let us recap what we have discussed in this class once again. Okay, so in this class we have discussed the mandatory contents of resolution plan. What should be there in the resolution plan? Then subsequently we have discussed what is insolvency resolution cost, what is considered to be insolvency resolution cost. Then we have discussed about payment to operational creditors. Okay, so when you are making the payment to operational creditors, you are supposed to consider the concept of minimum value and payment in priority. Suppose if any financial creditor is a dissenting financial creditor, that means he has not approved the resolution plan, then he is also having a right to receive the payment in priority. This concept we have discussed in this class. Then contents relating to avoidance of transaction. So how you are going to deal with the avoidance of transaction in the resolution plan. So what should be there in the resolution plan? Then treatment of provident fund. How you are going to treat with the provident fund in the resolution plan. Okay. Then resolution plan cannot contravene other provisions. Okay. So though IBC overrides other provisions or other legislations, it does not mean that you are going to violate other legislations. Okay. So these are all the various points that we have discussed. And subsequently we have discussed voting on the resolution plan. So these are all the various points that we have discussed in this class. Thank you.